Good evening, good morning, good afternoon, wherever you are, and welcome to session 4 of Avoiding Pitfalls in Arbitration. Thank you for staying with us throughout this period. Thank you for staying with us thus far and following all the sessions. It is my pleasure to introduce this panel. I will first start off by giving apologies for Mr. Kamal Shah, who is the moderator for this session, who cannot make it right now, but will be joining us a bit later. And Tom Schneider is another one of our panelists who will also join us a bit later. I will start off by introducing the speakers for this panel. I'm happy to say that it is an all-women power panel for now. Trust me, it was not by design. We have as our first speaker, Ms. Tafadzwa Pasipanodia, who will be speaking on cost and damages assessment. She is a partner at Foley Hogue, which is a law firm in the US based in Washington, DC. And Tafadzwa has a great practice where she practices natural resources, mining, environment, infrastructure, health policy, and the law of the sea. I know personally that she has represented several African states in investment arbitration, more recently a case involving Mauritius. So I'm sure you will appreciate the kind of insight that she will have. Our next speaker is going to be Luisa Setina, who is director at Anjawala and Kana Advocates in Kenya. And she also has experience, especially in dispute resolution, forensics, and investigation. I know her as a forensics and anti-fraud expert. She was previously a corporate litigator at White & Case in New York and has been ranked by Legal 500. Last speaker is going to be Jane Davis Evans, who is a barrister in the UK at 3 Verulam Buildings, and she is highly ranked in energy construction and international arbitration. She practices in a lot of African disputes, and I know she has represented several states, including Tanzania, Uganda, Sudan, Kenya, and Rwanda. Now, I will touch on the other speakers, Tom Schneider, who will be speaking on arbitrator bias and challenges. And he is partner for dispute resolution and arbitration at Al Tamimi in Dubai, a large law firm in the UAE. And he is highly ranked in a lot of the international rankings, and was more importantly very involved in representing the Ethiopian government before the Eritrea-Ethiopia Claims Commission. So you will agree with me that this is a great, great panel. Now, I will start off with you, Tafadzwa. If you can just briefly give us your introduction on costs and damages assessment in international arbitration.
Thank you so much, Warimu. Good morning, good afternoon, good evening, everyone. It's such a privilege and a real joy to be with you all in this virtual platform. Congratulations to Warimu, Leyu, Elodie, and Steve, and Agnes for this excellent conference. That's only missing the beach and the as Lehu said, but it's been wonderful so far. And I'm especially delighted to be on this panel with Louisa and Jane talking about pitfalls in arbitration. And I will be focusing on costs and damages, which is a topic I find particularly important. And I think, as many have observed, it's kind of ironic that even though damages are the end game, that's why people bring arbitrations, that's what states are and respondents are trying to avoid. It's often an afterthought for arbitration teams. The damages team is often separate. It's very technical. Nobody really wants to think of it. Every respondent hopes they will win on jurisdiction, on merits, and that's often the case. But of course, sometimes we do get to the damages phase. And in our experience, if you're not prepared by the time you get there, it's almost too late. And so it's an issue that I think is really important that arbitration teams have to start thinking about right from the onset. I also think it's an important issue on the policy level that's ignored. We have a lot of efforts at reform going on right now. We see how, for example, FET is being, states are explaining what they meant by FET and that they're restricting it. There's a discussion of whether or not to include investment arbitration in the African Free Trade Convention, Continental Trade Agreement. But there's very little discussion on how to reform damages. And yet we have gone from a situation where 2 decades ago, it was alarming to see an award of tens of millions. And now we have many mega $billion awards. And we even had a $50 billion award. And yet there isn't an effort to reform. And so I'm so happy that this topic is on the agenda. And I think it's an area that needs, hi Kamal. It's an area that needs disruption. So, we should all be putting ourselves together. And I want to give this example between Bear Creek, a case between Bear Creek and Peru,
Steven,
and another one between Tethya and Copper and Pakistan.
Can you see me?
Just to kind of highlight why this is critical, why damage is critical, and why it deserves our attention. So both of those cases were mining cases where the claimants had mining projects and were in the very initial stage, at the exploration stage of those of the cases. In both tribunals, both cases, the tribunal found that there had been indirect expropriation. In Bear Creek, Peru had been found to have canceled the investor's approval incorrectly, and in Tethya and Copper, Pakistan was found liable because it had canceled the mining lease. In both cases, the mine was never built. In both cases, there were genuine questions about whether the mine could have been built. Did the claimants actually have the capacity to build this project, to go through and to win, to have a profitable project? And in both cases, the tribunal held that the damages should reflect the fair market value. So those are all the similarities. And yet in one case, Bear Creek v. Peru, the tribunal awarded $18 million in damages. And in Tethya and Cooper versus Pakistan, the tribunal ordered $6 billion, including interest. Vastly different outcomes. Both of them used, in both cases, the claimant was asking for DCF, which is the discounted cash flow method. In Tethya and Cooper, they use a modern or modified DCF, which gave them even a more valuable project. If they had gone ahead with the normal DCF, the damages would actually have been zero. But because they used a different kind of DCF method that has a different analysis of risk and the time at which you're including the risk, the damages were up to $6 billion. So it just shows you how critically important this issue is and why it merits our attention. Thank you very much.
Thank you very much. And it is my pleasure to introduce Mr. Kamal Shah, partner at Stevenson Harwood LLP in the UK, who is highly ranked and is head of the Africa and India team. He wanted to make a grand entrance, and he achieved it. So welcome, Kamal, and please carry on with your questions.
Thank you. I should say I was on the beach and I had too many cocktails. So that's why I'm a little late in coming, and then technology failed me. So I'm really sorry, everybody. Absolute pleasure to be on the conference. And congratulations again to the EAIC team. You've excelled yourself, and the platform has worked very well, except for those of us who are hung up on the beach drinking cocktails. So I'm really sorry. Tom, my co-criminal, is still having a drink and trying to stumble his way to the conference. So please bear with him. And in the meantime, I see that it's going well. So Tefadzwa, you've done your opening. Could I ask Louisa, please, to do her opening, and then we'll move on to the others. I think, Wairimu, you've done the introductions, I assume. Thank you very much, and sorry everybody again.
All right, thank you so much, Kamal. We're very happy to see you looking nice and sharp and ready to go. So thank you very much. I'm really happy to be on this panel with these very experienced arbitration practitioners. I'm going to be talking about some of the trends that we have seen in the last few months and the types of contentious claims that have sprung up since the beginning of the pandemic, and the implications that we're seeing for dispute resolution in general and in arbitration more specifically. So it's a big topic. There are a lot of issues that were referenced in the subject line of this topic, but I'll try and keep it short where I can. So it's apparent that the fallout from the COVID pandemic has led to a sharp increase in contentious situations. At least that's what we're seeing on our end, and anecdotally, that's what we're hearing as well. So in particular, we're seeing increased reliance by parties on claims of force majeure, material adverse change clauses, frustration, and so forth. And we're seeing both legitimate attempts to rely on these clauses, but we're also seeing parties relying on these types of claims in an attempt to get out of what they're now seeing as bad bargains. But regardless of the merit of the case, we are seeing several of these types of cases at least come our way. So there's a lot of uncertainty for both the private sector and the public sector who are seeking to rely on force majeure claims. And I would say that there are mainly three reasons why that's the case. One, force majeure claims, or the doctrine of force majeure, is highly context specific in any case. There is an absence of clear precedent on the interpretation of these clauses in the case of global pandemic, because there actually hasn't been one at this scale for about 100 years. And in terms of precedent, by the way, from an arbitration perspective, some people see it as a challenge now that we're going to start seeing a number of cases come before arbitration tribunals, in ensuring that there's a consistent approach to handling these types of cases, because of course arbitration by its very nature is confidential. And so practitioners perhaps need to find a way to share information about how these cases are decided, so that there's some sort of even playing field or understanding about how to interpret these clauses and handle these matters. But the third reason why there's so much uncertainty is just because obviously the economic, the regulatory, and the social landscape just keeps changing. And what does that mean? That means that parties are unable or unwilling to make very medium or long-term drastic decisions. They're having to make decisions that are more immediate than that. And that has implications for dispute resolution that I think are quite interesting. So given the increase in number of disputes and the increase in contentious situations, there is going to be an increased demand for arbitration and just dispute resolution in general, which may place a strain in the whole practice in general. So that means that practitioners, arbitration centers, arbitrators are going to have to deal and adapt to the caseload. The good thing about the pandemic, if there is any, is that at least it has pushed for the fast tracking of the implementation of certain solutions. For example, with regards to e-bundles and remote hearings and so forth. But in my view, there's more to be done. There's going to have to be thought given to how do you train arbitrators faster? How do you add more arbitrators to the roster? More centers are probably, in my view, based on what we're seeing from clients, going to have to add expedited fast tracking proceedings. And some of these centers don't provide for that, like the LCIA, for example, right now, which provides for expedited constitution of a tribunal, but not for, say, resolution of a dispute within a shorter time frame. And in addition to that, we're seeing a clear trend that just of an unusual sense of urgency by the clients that we get. For some of them, even arbitration is feeling too protracted right now, especially given some of the costs that they're incurring from delays to the resolution of disputes. So, for a lot of clients, there seems to be a need for faster and simpler methods of reaching resolution of their disagreements. And some of the arbitration centers are actually just trying to meet that need. For example, the London Chamber of Arbitration and Mediation in June of this year published their new rules on expedited arbitration. In addition to that, there are a lot of cost pressures. Obviously, because of the economic distress, clients are making different calls regarding how they want to spend their money. And we are seeing more pressure towards settlement, for example, or renegotiation of contractual terms in efforts to avoid dispute resolution. And you know, this is in situations where perhaps that is not ideal, but they feel that they can't really justify an 18 to 24-month arbitration process, for example. And then finally, two last points, which I think are part of the trend. Some people are saying that there's going to be a protracted process for the enforcement of proceedings, and this is due to backlog in the courts, a backlog in general from enforcement cases, and just because of the economic distress, there are less assets that people can collect, and you know, parties are going to try and hide some of their assets and divest them, and so forth. And finally, probably we will see a growth in third-party funding because people can't afford to fund their own disputes, and because of the increase in the number of the disputes that we're seeing.
Thank you, Louisa. I have a few follow-up questions, which I'll come back to, if I may. Could I ask Jane perhaps to leapfrog Tom, who's still trying to get on, and Jane, talk to us about cross-examination and all the fun you've had doing it in the last 6 months.
Thank you, Kamal, and good to see you on here. Well, we were enjoying being just females on the call.
Yeah, I'm sure it was all planned.
So looking at the pitfalls of cross-examination in arbitration and how you can avoid those, and of course, you know, now that we're moving to many virtual hearings, that's just sort of increased the risks and the issues that arise. I think what's really important to remember with cross-examination is what is the primary purpose. Because I think probably when I first started practicing, I used to think that cross-examination was my opportunity to damage the other side's case. And to some extent, I think that's true. But I think actually the primary purpose of cross-examination is to improve your client's position. And so every time I'm looking at what I'm going to cross-examine on, who I'm going to cross-examine, the questions I'm going to ask, I'm always thinking, is this particular question or line of questions going to improve my client's position or not? Because although we can often think of cross-examination as your opportunity to put the knife in, metaphorically, I always think you have to remember that every time you ask someone a question, you're actually giving them 3 opportunities to improve their case, because they might give a good answer or on to you, or they might be re-examined and give a good answer, or you might have piqued the tribunal's interest and therefore the tribunal ask a question and they give a good answer. So you've got one opportunity to get the knife and score a point. They've actually got three opportunities to come back. So I think it's quite important to remember that and not over cross-examine. And certainly as I've got older, I cross-examine less, and in particular when I'm on virtual hearings, I cross-examine even less than I did previously, but I think probably more effectively for that. The other thing, of course, is to remember to focus on your client's objectives. And certainly in most of my arbitrations, my client's objective is to get money or to avoid having to pay money. So it's really important to sort of follow the money, as it were, when you're cross-examining. And with your fact witnesses, thinking, okay, what do the experts rely on for the purposes of valuing these claims and attack there, and then look with the experts, look at where is most of the money. And a pitfall that I think a lot of people I see do, both as opponents and also when I'm sitting as an arbitrator, is they quite often pick the easy topics on quantum because they think it will be easier to cross-examine, and they will be able to then argue that the credibility of the quantum expert, for example, has been damaged and therefore the tribunal won't rely on them. But quite often you'll see people are maybe cross-examining the quantum expert in relation to, say, a claim that's worth maybe $20,000, $30,000, $40,000, while the entire arbitration is worth in the hundreds of millions. And you can see the arbitrator sitting there going, why are you wasting our time on this? They know exactly what you're going to do. You're going to try to make an argument at the end that the expert isn't reliable. But I don't think it's terribly effective. And frankly, you're wasting the time, and it's quite annoying for tribunals when people do that. The other thing is to really identify the best path to getting the answer that you want. And for me, quite often, it doesn't matter whether the witness I'm cross-examining or the expert agrees with me or not. I don't need to persuade them to agree with me to get the concession, because sometimes the fact that they disagree is almost more damaging to them. And so what I'll try to do is find a pathway that will walk the witness or the expert to where I want them to be. I'm essentially corralling them into the corner, and then I'm going to ask a question where they'll either have to agree with me, or if they don't, that it will be so damaging to their credibility that they didn't, that actually it's even better than if they had made a change in position. And I think that becomes even more important when you've got virtual hearings, because in virtual hearings you need to be even more selective. And you think, it's really important just normally in a normal hearing to think, is there a clear path to get where I want to go, where they're not going to be able to give a good answer, whether they agree or not is going to be damaging. And that might be, you know, is it a simple step, maybe 3 or 4 documents, 3 or 4 introductory questions to get there? Or is it so long and convoluted that I'll lose the tribunal, or I might lose the witness on the way? And you need to be even more selective, I think, when you're on virtual hearings, because you have even more scope to lose the track of where you're going along the way. I think the other one I was going to say really is to be very clear, what do I need to prove to win, and to monitor that at all times going through the hearing, because the mantra we were taught, certainly at bar school when I was younger, is more is not better. If someone has given an answer that is good enough, stop. The biggest pitfall is carrying on and asking that one further question that you think is going to give a great answer, and the witness recovers. And you think, if only I'd not asked that question and stopped, it would have been much better. And certainly I've had many instances where, in fact, asking 1 or 2 questions, I get an answer that is possibly determinative. And while I'd intended cross-examining for maybe 2 or 3 days, I stopped 10 minutes in because I've got everything I need from this witness. But you have to hold your nerve, and because it looks very strange to suddenly stop cross-examining the main witness very early. But sometimes that is actually the best thing to do. So, Kamal, I'll stop there for now.
Thank you, Jane. This is a topic which has become even more important now, and one of the things you touched on is stopping early sometimes helps. We as the advocates are under pressure often from our clients who really want us to draw the knife in and twist it 100 times. But what you say is very important. What has been your colleagues? I know many of them at 3 Verlin buildings have been involved in virtual hearings. What has been their best and worst experience? What have been the difficulties in cross-examining, whether it's in court or arbitration proceedings? I think if you can share 1 or 2 stories, that would be great.
Absolutely. I think the fear is always, and this was even pre-COVID, that if the witness isn't in the room with you, that sometimes they're not even the witness. I had a case last year where it wasn't even the individual it was meant to be who was peered, and it can be very difficult to check identity. Someone holds up their passport and you can't tell on a video if it's them or not, but also who's in the room with them, or maybe they've been a bit more sophisticated. Someone's not in the room, but they've got some way of communicating. So I think those are the issues. But I think what I was talking to some of my colleagues, what we've all found is that you can tell when someone is being fed the information. And it's in fact on Zoom, I mean, as we can all see here now, we can all see each other's faces really quite close. You can see where people are looking, you can see their expressions. So I think that actually people do their cases a lot of harm because they think, oh, it's on video, no one can see. Well, in fact, you can tell. And so I think that's the biggest issue that we have, that people have said that they have. It's It's people being fed information, but actually most people aren't that concerned about it because it's so obvious when it's done that it's far more damaging than helpful to the other side's case.
Thank you. I'll come back to you. Can I just go back a few steps to Fajwa and your opening remarks about costs and damages and the issues we have, the differences we've seen. One of the hot cases at the moment, which you will have touched on, is the process and industrial development case against the Ministry of Petroleum in Nigeria. Many of us have been following it or have been directly or indirectly involved. There are so many lessons to be learned from that case, which succeeds many others before it, where issues of fraud and corruption and all these good things have come to the light in the local courts and the international courts. What might African states do to avoid all of these pitfalls of such a case? I'm not asking just about PNID, but what is your experience? Because your firm has been involved in many cases for mainly states, and of course we've worked with you on cases as well. What do you have to say on that?
Thank you, Kamal. Thanks for that question. It's a really important one, and I think, as you said, there's so many things when you get to a mega billion-dollar award case. There's so many things that could have been done differently, right from the contract to the arbitration and everything along down to the cross-examination at the hearing. So there's a lot that can be done, and you can see it more clearly in retrospect, of course. But I just focusing on the damages part and elements. I think there are a couple of points I would highlight. First is I think that respondent states need to pay more attention to causation, because often in a case you will have a very inexperienced investor who is claiming billions of dollars for this wonderful project that they would have had, but for the state's wrongful act, they would have made billions of dollars. And I think it's very important for us as counsel to focus on that causation stage before you get between liability and damages, because under international law, the state is only liable and should pay compensation for wrongs that they have for harm that arises from the wrong they've caused. So if the claimant had if there's any other reason that the claimant might not have had this magical project worth $6 billion, the state should not be held responsible, even if it acted in a wrongful way. And one example of this issue in arbitration is with the Bywater Gulf v. Tanzania case, which was a case where the tribunal found that and Tanzania acted wrongly in its termination of the water concession, but there was zero damages, despite the wrongs that they found, zero damages, because there was the realization that the claimant had contributed in some way, and that really this project, they wouldn't have made money anyway, whatever happened with the state. And so it's an important issue. And it's an issue that requires the merits, people working on the merits and facts, talking to people on damages right from the beginning. Because looking at one of those mega billion awards, I noticed that the tribunal members said in their award on damages, the respondent state accepted everything that the claimant's fact witness had said about how the project was ready to go. Everything was wonderful except for the state's action. And the state didn't challenge that right at the fact stage. So when it got to damages, it was too late for the state to say, hold on, there were all these things that needed to be done. It was too late. So it's a reason why I think there needs to be more collaboration between the two. And then I would just focus as well on the cross-examination. And this leads off from what Jane has been saying about the importance of cross-examination and the need to be very clear about what you want to achieve in cross-examination. In one of these mega billion-dollar awards, the tribunal noted over and over that the claimant's expert had not been challenged by the respondent state on a specific assumption related to damages or a specific assumption related to the DCF method. And so it's this balance. Yes, you don't want to just ask questions that you don't know the response to, but we have to, as counsel, learn the language of economics, of finance, and really understand the issues that are at stake in valuation and ask the right questions that will further our client's perspective, because otherwise the tribunal will say, well, we're going to go ahead with what the claimant expert says about all of these issues, all the assumptions that get you from going to zero damages to $6 billion damages. We'll accept it because the respondent state didn't really challenge those.
And I think that's a very important issue. What you mentioned earlier about going back to the contract and the contract award stage. Often the issue for us as lawyers, isn't it, is by the time the dispute comes on our desk, it's been a decade or more from which the contract was signed, and those who signed the contract at the government end have gone on to do other things or may have passed on. Who knows? So I think having these systems in place and having a very clear line of communication is absolutely key, and thinking 5 or 10 steps ahead, because claimants, of course, will be doing that. So that is very important. Louisa, can I ask you? You mentioned that, and we found that as well. If clients want to settle as quickly as possible, they don't want to spend a lot of time and cost, particularly in the current climate. Do you think arbitration is taking too long? Are clients looking at other forms of dispute resolution, like expert determination? What's your experience been? I'm sure you've faced a number of these issues sitting in Nairobi in the last 5 or 6 months.
Yeah, thanks, Kamal. Yes, we have faced a number of issues that just deal with contractual disputes that require quick resolution. And yeah, we have seen increasing pressure from clients to find ways to resolve these disputes faster, even where settlement is just out of the question. They are currently thinking that arbitration that may take 18 to 24 months is a bit too long for them, because each month that a particular project, for example, gets delayed, it costs them $10 million. And so they just need a resolution that's quicker than that. So we have seen, for example, where a particular agreement has both an arbitration clause and an expert determination clause, clients trying to find a way to rely on the expert determination clause. But we have also seen, just because expert determination is not as common a method of dispute resolution, that often the clauses are quite weak. They're not properly drafted in terms of how you appoint the expert, the jurisdiction of the expert, the finality of the expert determination. So I do think that based on the current situation, there is probably going to be an exploration for more expedient types of dispute resolution, whether it's mediation even, or expert determination, because it does have a few advantages. For example, just expert determination is quicker, it's a lot cheaper. We just did one, which was like a $60 million expert determination, which we're still in the midst of, in which we got a determination from the experts 2 weeks after the hearing, which would be unheard of in other proceedings. Although there are issues about the finality of that determination, the fight goes on. But normally, not necessarily in this case I'm talking about, it's less adversarial. So at least it allows for the parties to maintain some sort of just commercial rapport that is a little bit less antagonistic. And normally there is more finality to an expert determination if the expert determination clause is properly drafted. There are some disadvantages, which is a process for determination that is more familiar, and so there's less of a body of law. The case law is less developed on the topic, on the jurisdiction issues, and so forth. There's uncertainty on the jurisdiction of the expert, and then when it comes to enforcement, the mechanism, it's a little bit perhaps less efficient, because you would enforce it in the same way you would an agreement. So you would have to make an application for specific performance or an action for breach of contract if the losing party doesn't pay. But having said all that, I do think that arbitration is still going to come on top. Obviously, it's still going to be a much more viable form of dispute resolution, just because it's quite adaptable it has made a number of changes, for the last several years, but especially quickly in the last several months. And UNSTRO, for example, started compiling rules about expedited arbitration. As I mentioned, the London Chamber of Arbitration and Mediation also launched its expedited arbitration rules in June, I believe, of this year. The ICC has its own rules, although the value of the dispute is perhaps a bit too low. I think there are parties who may be willing to risk having provided resolution for higher value disputes potentially. But then LTIA doesn't have one. So I do think that these are some considerations that should be taken, that should be kept in mind.
One of the things that we have been talking to some of our local friends and colleagues about in Africa is whether their clients are taking their cases out of court and moving to some sort of an expedited arbitration, whether ad hoc or under institutional rules. Have you seen much of that? Because I know the courts in Kenya, I spent 5 months during the lockdown there. The courts, some judges are okay in terms of virtual hearings, but many are not. Have you seen that kind of trend where you're taking the cases out of court and moving them to some sort of expedited arbitration scenario?
I mean, I haven't seen enough volume to say that that's a trend, but I would definitely see how that would be a decision that would be natural for the parties to make. But of course, it depends on the sophistication of the dispute. Obviously, if you're looking at a very complex infrastructure or construction arbitration, you might be hesitant to bring this before a local arbitrator. So it depends on the form and the nature of the dispute. I do think that, for example, for more simpler commercial disputes, or lease disputes, that sort of thing, you would see a trend like that, and that could also help with the backlog in the court system. I think there would be a different approach the more complex that disputes gets. And of course, if you're talking about the billion-dollar type disputes that Jane and Tafazzo have been talking about, then that's a different scenario.
Yeah, thank you. Tafazzo, if I may come back to you, costs have been a hot topic of discussion, and the fact that we are saving our clients lots and lots of money by not traveling, not staying in hotels, not eating out while we're on site for arbitrations, and saving, making arbitration greener. How do you and your firm see that longer term once we get to some sort of normality?
Thanks, Kamal. I think the longer this goes on, the clearer it is that we can survive without a lot of the travel that we have become accustomed to doing. And I think clients will indeed ask for more to be done virtually because of the cost savings in terms of travel. All the aspects that you mentioned are critical and are huge. I think we will see an arbitration reduction in costs, but I think in terms of legal fees, just seeing how I have been working hard throughout this lockdown, I don't think that the fees themselves will decrease dramatically, because we are still doing the work that we're doing, and it requires the same level of work. It's just that we're trying to do it virtually, and there are definitely cost savings to that, but probably the fees will stay the same because we have to do the same. And I think where it becomes difficult with travel is with talking again about damages, getting experts to the site to look at the environmental harm, to look at what really happened on site. I think that kind of travel will still have to happen, and is really important, because it's very hard for people to assess environmental damage, for example, without being able to go there. But I think we're seeing in general a new, as Louise also suggested, it's a new paradigm post COVID-19 with arbitration in general.
One thing that we have struggled, I think, somewhat with as a team, as a firm, and I'm sure there's common ground there, is actually getting instructions from our clients and witnesses on sometimes very complex issues, whether it's factual expert or other instructions where we could just hop on a plane, whether it was down the road from Nairobi to Kigali or from London to Nigeria. It is much harder, made even harder by these virtual platforms where you can't really show each other the documents as you would sit next to either point at the wordings. Can I ask each of you to share experiences, good, bad, and ugly? What's your experience been? Because I think we have struggled at points, and you've then got WhatsApp going on, you've got these platforms going on, you try and it is hard. Jane, perhaps you first.
Oh, yeah, no, definitely, Kamal, I agree. I mean, I do a lot of construction, and I've actually found over the years that the best way to get good witness statements and also expert reports is to go to the construction site and so not even sitting with them with documents, but actually physically walking around the construction site, because then someone says, oh, I remember this, I remember that, and it also makes the story much more real for the tribunal as well. You can interpose a lot of photographs or videos or things. So having to try to take very lengthy witness statements, as you said, often about things that happened maybe 10 years ago, when somebody has got lots of other pressures on their time and you're trying to do it by WhatsApp or something, it is really difficult. Also, there's nothing like when you really need some instructions because you've got to go back to the tribunal, just saying to your client, I'm flying in, I'm going to be there 2 days' time, you need to see me. And if necessary, you just sit outside the Attorney General's office, or you sit somewhere I've sat on the floor, spent many an hour sitting on the floor outside various Attorney General's offices, waiting until they give in and go, okay, we'll see you, to get that half-hour audience, get the instructions. And it doesn't particularly work. I must say my personal advice is if you send WhatsApp messages to people about morning church time on a Sunday, you will find that's when people will be sitting in church and they will answer your messages. That's my tip. And my clients said that they all admit that's what they do. They say it's the best time to get hold of us is morning service on a Sunday. But it is really difficult. And we just have to become innovative as to how we get our clients' attention.
Thank you. I won't comment about morning service. Start another debate. Tefazwa, what's your experience?
Yeah, I definitely agree with Jane and everything that she said, and especially certain disputes like construction. I can see exactly what she means. In a case we just submitted a counter memorial, there was an environmental damages aspect. So the state was making a counterclaim on environmental issues, saying whatever the claimant says, this is the damage they've caused to us. And it was very hard to make that without our experts having been able to go there. So we did, we sent a camera over. Our experts were in England. They sent a camera over to the country in Latin America, and then the officials, the environmental officials, walked around with the camera and being pointed to what to look at and so forth. So in the end, we felt we made a good case under the circumstances, and you do have to kind of be creative in that sense. And then a positive aspect, I think, has been with witness statements. Usually you meet with witnesses in a room, in a conference room somewhere. And now we are doing it virtually. So they have their computer, and all of the documents that you might hope to have are there on their computer. So in sometimes it's been great to ask a question and they've said, oh, I have a document that shows that. And they've they've shared their screen and it's there. So, it's got its challenges, but we just have to try to look for those opportunities where it's more helpful in some ways.
Yeah. Louisa, what's your experience been?
Yeah, it's interesting. It's a little bit different from Jane's and Tafatu, and I'll explain why. But I also think it's more fundamental than just the interaction with the client, because I think it also impacts how you work as a team within your own law firm when you're all dispersed and the meeting of the minds, just being able to work through problems and brainstorm and strategize, etc. And it also impacts not just third parties, but your rapport with a client when you're dealing with a very intense situation, with a very, just complicated issue, and your client is getting, say, just frustrated with the process, etc. It's harder to manage that over a Zoom call that may freeze or drop and so forth. So I think it has implications from a case management perspective as well. It's interesting from the standpoint of meeting witnesses, etc., because based on the ground, we're not that often in a situation where we're international counsel and then our witnesses are in some other country. Most of the times our witnesses are here, so I've been in situations where I absolutely have to meet with someone just because it's a particularly sensitive issue. I have been able to meet with them. We haven't had a formal lockdown in that sense. Where we normally do things remotely is with clients abroad or with international counsel in London or the US and so forth. And then we just have the typical technological issues that you've all been mentioning.
So I think the moral of the story is when our clients are complaining about going fully virtual, there is some merit in meeting. And I think that's what we've realized. We don't need to meet all the time and fly all the time, but there is certainly a lot to be said for face-to-face time, and I don't think that'll change once we're all more comfortable about flying. We have a couple of questions on the chat that we should look at as well. Let's take Pamela Muruka first. Do you think it will more value add if advocates incorporated experts at the strategy stage prior to even drafting or quantifying the claim? That's a good question. Perhaps Tafazwa, you'd like to take that, and then Jane and Louisa can comment if they want.
Thank you, Kamal. I think it's a great idea of Pamela's. I think there's a lot of benefit to the team to have experts be involved right from the beginning. And obviously this is a cost issue again, but I think in the end, the clients are better when they have benefited from the advice of experts early on. And if they're talking about valuation experts, we have seen that our merits case is strengthened by having people who are experts in finance and technical aspects and financial aspects be involved right from the beginning, because they can look at all the financial statements that we might not be able to understand. In the case that we just filed, our valuation experts were able to see that at some point the claimant noted an impairment of the value of their project after they got bad test results. And so that was great. We wouldn't have noticed or understood really what is impairment, but it's basically realizing that your project has less value than anticipated. So it was incredibly helpful to have that expert input, and then now ask our witnesses, oh, we understand this, what can you say about this? But so there's a lot that can help with both sides with having experts involved early on. And I think it's worth the extra money.
Yeah, and something we do certainly as a team early on is look at that, not just the witnesses, factual witnesses, but the experts as well, and where the case merits it, trying to get one or two of the best experts, for example, leading documentary experts. There's not many in London, conflicting two or more of them so that the other side can't get to them if the case merits, and the client is often supportive of that if you explain to them why you're suggesting doing that, because we've had cases where we've conflicted two or three of the world's experts on documentary expertise, and the other side contact them and they can't act for them. What's your experience, Louisa?
Yeah, no, I definitely would agree that bringing an expert in early on does a number of things, including having a chance to hash out with the client how things may be understood from a third-party perspective. Right now we're in a situation where a client decided to make a very expensive decision without necessarily going to an expert, a technical expert, and now obviously they're in a situation where that has led to a dispute that now is going to have to be determined before either before an arbitrator or an expert. But the point is that if they had consulted someone at the beginning, even if the client had decided to make a decision from a risk-based analysis or to still go that route, they would have at least been able to consider another perspective. And in another matter that we're handling, bringing in an expert eventually helped us as legal counsel sort of get the client to understand that the position that they were taking, I don't want to say it was unreasonable, but it was a little bit extreme. So, obviously, if you have the funds, the time, and the long-term view, it's better to bring in someone early on.
I think the issue often we face is convincing clients to incur that cost early on, and it is not easy, particularly when you have government clients who are always short of resources, whether it's money or time or both, and it is really hard. You need to win that trust early on to be able to convince them to front load some of these initiatives, which will help them hopefully later down the line. And Jane, I know you do a lot for governments, including the Tanzanian government, which is not easy to work with, as we all know. How have you managed to convince them on some of the strategic aspects of your decision making?
Well, for experts, I think my personal bugbear with experts is that the majority of people who appear as experts in arbitrations nowadays are experts in being an expert. And a lot of them will have had very little real life experience, or certainly not maybe for the last 20, 25 years, of actually doing what they're purporting to be an expert in. And that drives me mad. I'm an accountant as well as a lawyer, and absolutely drives me mad where you get people who've spent a very little period of time in the what I call the real world, because frankly, arbitration isn't the real world. We're in this little fantasy world on the side. And it's and so I tend to, wherever possible, I will actually instruct or recommend to the client that they instruct retired individuals who have 30, 40, 50 years experience doing whatever there's required. And the clients often prefer that because, say, I do a lot of work with, for example, say TAN roads. You bring along someone who has been a project engineer for 40 years and somewhere in the world, the client understands and talks the same language of that individual, far more so than if you bring someone along from one of the international consulting firms who you typically see as an expert. And yes, you'll have to do a little bit more work with them because they might not have written an expert report before, they won't understand the process. But at the same time, I think you get a far better report, a far better quality of expertise. But also, very importantly, they'll often be a fraction of the price because they'll be someone who's just happily retired, happy to work for maybe $100 an hour, while you'd normally have been looking at $600 an hour plus a full support team. So I think that can help. But just to sort of give one story on that, and it sort of comes back to the cross-examination as well. Just recently, I was cross-examining someone who claimed to have about 30 years expertise, and this was in a case for the government of Tanzania. And we had our suspicions. So very early on in the cross-examination, I was trying to ascertain exactly how long he'd actually spent as a civil engineer, which was working on site. And he admitted, I thought he would have lied, but he admitted he'd actually only worked as a civil engineer on site for 3 months. And I cannot repeat, because it's so rude, what the Australian presiding arbitrator muttered under his breath, possibly more loudly than he meant when he said that. And then which I went, okay, thank you, I have no further questions. And the other side were apoplectic that because they were clearly going to use him to improve their case, which was terrible. And I just said, he's not an expert. I might as well, I might as well give some evidence on my own client's case. And I just stopped. And it was a good example, I think, of stopping. But also, it was a shocking example of someone who was there. I mean, for the Tanzanians on the board, on the call, will also appreciate, they called an Indian engineer as their Tanzanian law expert. So again, one question: are you an expert in Tanzanian law? No. Are you a lawyer? No. So thank you, I have no further questions. I mean, it was, but millions of dollars had been wasted on cases that were founded on people who were frankly charlatans. They weren't experts.
Yeah, and
that's my rant about experts.
we all have war stories along those lines. Can I just ask, since unfortunately we couldn't get Tom on and his topic was going to be about arbitrator bias and challenges, can I just take a step back? We've got about 10 or 15 minutes, And since we have the three of you here, can I just talk about the issue of selecting arbitrators? And that is connected to the equal representation in arbitration pledge and the African promise, which we are all having at the forefront of our mind when selecting arbitrators, advising our clients. What is your individual experience and how have you gone about it to make sure that your firm, your team is very mindful of these pledges? You come from very diverse firms and chambers, but there's one thing in common, that we all want to see more Africans on the panel. We want to see more female diversity on the panels. A few minutes perhaps of your personal experiences. I'm sure the audience would love to hear that, and hopefully we can get some chat going as well. Louisa, perhaps you'd like to kick off first.
Sure, thanks, Kaman. Obviously, I have a lot less arbitration-specific experience than Jane and Fazwa do, or you, Kamal. So I think it'll be very valuable for you to chime in. But in the matters that I have handled since I've been back in Kenya, we actually oftentimes prefer by far to have, let's say, an African arbitrator or someone with a lot of African experience than a Swede, just because the context is so relevant to commercial disputes. We've been doing mainly shareholder disputes, and often involving, say, like regional conglomerates, local businessmen who've been very successful, but they've grown their companies in a local context. And so when we've been discussing who we would appoint and who we would go for, we definitely try and prioritize an understanding of what's happening on the ground. We think it makes a big difference. Of course, when you're talking about different types of arbitration, like construction arbitration and so forth, or investor state arbitration, you need someone who is very familiar with those specialisms. And so sometimes you may not have the luxury of finding someone who understands the context, etc. on the ground. You may have to go for someone who is an expert in that particular type of arbitration. But that generally, that's been my experience. And obviously, when you're selecting arbitrators on the ground, integrity is probably the biggest red flag at the top of any decision-making tree, unfortunately.
Thank you. Fazwa, perhaps from the US, and of course your firm is involved in numerous of these government type of arbitrations. What's your experience been?
Yeah, it's such an important issue, because I think that's one of the most important, obviously, decisions that you make as counsel, who you appoint as the party arbitrator. Very little matters after that. And so it's a critically important decision. You really want to focus on what's best for your client primarily. Who can you pick? Do the research to know what the record of the person is the person you're recommending, and make sure you're recommending someone who has the best chance that they will see the facts in light in the way that benefits your client, and that they will rule in a way that will benefit them, and looking at their record is really important. So that's the most important aspect of us, and for us, and the way that we can get more women or more people of color, and particularly in African cases, more Africans picked as arbitrators, I think, is to get their records out. And I love that this conference, Wairimu and Agnes and Lehu and Elodie have the arbitration awards, because that way people are finding out, oh, they're these people, and these are the cases they've had, and this is why they're wonderful. Because as counsel, you really want that assurance that you've done your best to pick somebody who's going to perhaps see things in your view, and there's never a guarantee. But I was shocked at one of the arbitration. In two of those mega billion awards, there's the same European white male who has decided both of those mega billion awards. And in one of them, they were picked by the respondent state. And it's such a lost opportunity, because this is your chance to pick somebody who, when you already have seen that they have these kinds of award, it's just critical to do the homework. And it's critical for all of us to speak, to let the records of African arbitrators that we've worked with be better known to others.
Yeah, that's a very good point. Jane, what's your experience?
I mean, I think one of the difficulties that African states often have, if you're looking at the African perspective, is they're quite often the respondent, and the claimant will have gone for one of the big names, a retired judge, a QC, or sort of one of the great and good of the Swiss or Swedes or something. And it can be, so your concern then is, well, if I pick a lesser known African arbitrator as the respondent's arbitrator, are they going to be ignored to some extent? I mean, what I've tried to do is recommend an equivalent weighted arbitrator to be appointed by the state, but to make sure that I know that arbitrator is committed to diversity and will be committed to putting forward as much as they can, that it will be, there will be a female presiding arbitrator, or there will, even more so, there will maybe be a female African presiding arbitrator, because of course then the more that these very heavyweight arbitrators see African arbitrators doing a good job, plus the African arbitrators can learn from these very experienced co-arbitrators, their capacity building at the same time. I think it also gives the award more credibility, frankly. I mean, if you've had 3 white elderly gentlemen deciding an African award and the African party loses, there'll be part of them which is thinking it's just because there was some unconscious bias. And so you get a much more credible award if there is an African arbitrator or more than one African arbitrator on the panel.
Yeah, and there are so many good names out there. I think I find one of the issues is they're not promoting themselves with the institutions. Colleagues are not promoting them perhaps as much as we should. And so there's a number of issues there, because the same names get picked again and again, whereas below that there's a number of layers of up-and-coming arbitrators or established lawyers who would be perfectly suited to the job. There's 1 or 2 more questions I want to just pick up. There's, I think, Mercy Okiro. What is the panel's take on double hatting by arbitrators, keeping in mind that most diverse arbitrators have to do this as they look to build their profiles? Would anyone like to take that question?
I could start. I think it's a very important issue that really risks undermining the system and the legitimacy of international arbitration. When people from outside look at the system, and especially where you're getting huge $1 million awards, and say the people deciding were people who have cases where they're working on the similar issues and have an interest in it going one way or the other, they're appalled that this is what's happening. And so I think it's a really important issue, and one where possible we should try to avoid double heading. And I think that there are many African judges and people of high esteem who are focusing now on just arbitration, and they're not serving as counsel, who we should be looking to for diversity, even though it's a bit more challenging to have to have someone who's not double heading. But I think it's really important for the legitimacy of the system.
Yeah, agreed. Jane, Louise, anything more to add?
I think I've just been pleased to say, I mean, certainly there have been a few decisions recently from the World Bank and elsewhere where they've been taking, I think, a much sterner approach to sort of disclosure of potential interests and things. And I know that some arbitrators are really anti that, but I think we have to remember we're providing a service as arbitrators and as counsel to our clients. And if by not disclosing something, we reduce the value of an award somehow, we're underperforming. And so I think I always go for over disclosing, if anything. But I think that's important.
Yeah, and it's really, you feel gutted when you have to say no at the very start when you're asked by an institution, whether it's an international institution or a local institution. But saying no for the right reasons actually means that they will come back to you, hopefully, because you said no for the right reasons. Whereas accepting it and then 6 months later, someone raising it and you being embarrassed and the parties then challenging you is just going to lead to so much more of a waste of time, cost, and reputation as well for you individually. I think Wairimu, you just came back. Would you like to say something? Do we have a few more minutes?
Yeah, well, you have 5 minutes more to go, but
have I missed? There's a couple of. I'm struggling to see the questions on my screen.
On your Q&A.
Are there one or two more questions you would like us to take? I have a few more questions of my own, but I'd like to take one or two more from the audience.
All right. Now, I don't know whether you asked about arbitrator bias and artificial intelligence in selection.
I haven't asked about artificial intelligence in selection of arbitrators. My extent of artificial intelligence is we have a list in my office of names, and we go through that often. But actually, the really juicy comments are held back in people's heads for obvious reasons. That's the extent of our artificial intelligence when it comes to selection of arbitrators. I find the best way is just to pick up the phone, think about each case on its own, and then talk to your colleagues outside the firm. I often call up Jane's chambers or my colleagues in other firms, say, hey, what do you think about these 5 names? I don't know how, perhaps Tafadze, Jane, Louisa, you can share whether you have a special list in your office.
I have a list in my head. In particular, the blacklist is hidden at the back of my head. So,
if I may address this one, no, I mean, obviously we don't use artificial intelligence yet for this type of thing, but I do think that it has a lot of potential, depending on how well educated the AI system is, because you can end up with a situation like in the UK right now with the grade system and what happened with the kids who are graduating and going to university and then being downgraded depending on where they lived and so forth. And you also have situations of the unconscious bias of the software developers. For example, in the case of voice recognition or face recognition, they realized that they were very good at recognizing white males, but for some reason, black female faces had like only 60% accuracy rate because they just hadn't fed enough of those images through the system. So I think my point is that obviously there is a lot of potential for AI just being a lot more neutral and trolling through databases that are a lot more extensive, a lot quicker. So I do think in the future that could be a very good resource to eliminate some of this bias that even African states have as said. As a partner at a local law firm, I can tell you that we often find out about RFPs from African states through an international law firm, because an African government will first go to London or the US before they come, and then we are appointed as local counsel. But I think it's a little bit early to go with that process. I think Jane's method of her mental Rolodex is safer at this point.
All right.
Yeah. Do I have 1 minute, Wairimu?
Yes, you do. There is one question from Aisha Abdallah that was not answered.
That's the one I was going to get. 20 seconds each. Aisha Abdallah, who works with Louisa in Nairobi, has a question, and she says, I have a question about whether the size of damages is fueling a backlash against international arbitration in places like Africa. And I think she's referring to PNID, of course, as well as a number of the cases we have seen from Nigeria and elsewhere, hundreds of millions of dollars against states or state entities like the national oil companies. What's your view on that? Perhaps, Tafadze, I come back to you. Your firm does a lot of state work, amongst other things. What's your view? Is there a backlash?
Yeah, it's a good question, and I just want to tie it also with Andrew's question from earlier about what African states can do about having more standardization of these awards, given the inconsistency and the damages awards. And I think there is a backlash, and it will continue unless African states make clear what their views are on damages. And very few people are talking about reforms on damages. I think it's great that SADC is one of the few entities that has put forward a bilateral investment treaty that that the BIT model doesn't have fair market value, or it says use fair and equity. It says I can't remember the exact language, but it's supposed to be a fair and equitable way of assessing damages, taking into account a variety of different issues. And I think we need more of that. Whether it's at the bilateral investment treaty, that states are saying very clearly what they expect in terms of damages and valuing damages, and then also at the contract level. We can't forget the contract level. P&ID was a case that wasn't even an investment arbitration. So nothing we're doing in investment arbitration, ISDS world, really will affect that. That's just about a contract and what the contract says about potential damages and mitigation. And so at that level, states have to be clearer about if there is arbitration, what the damages could be potentially, and putting caps on that. Thank you.
Yeah. Jane, you represent Tanzania, which has in many ways extracted itself from the whole scheme of international arbitration. I don't want to put you on the spot, but what are you able to say about that? Because it is very much highlighted in the recent developments, the actions it has taken.
I mean, I think actually if you talk to Tanzanian lawyers, that it's not seen as extreme, and certainly there's the new Tanzanian Arbitration Act, which is, it's a very modern act, which will be very familiar to many of us English lawyers in particular, which was, I wasn't convinced that was the way it was going to go at one point. So I think that's a very positive step. What I would say is I think there's been more a backlash against certain types of arbitrators rather than arbitration itself, because of course states want to win, and if they win, that outside sort of the ISDS world, a lot of the arbitrations I do, they're between investors and states, but they're essentially commercial arbitrations. And when we win, we want to be able to take that arbitration award and enforce it in all sorts of countries. And so we need an arbitration award quite often, but we would just be cautious about the type of arbitrators that get appointed.
Final thoughts from you, Louisa. Any more to add? Kenya has, of course, done very well in arbitrations recently, where it's beaten away the opposition. So there's no chance of Kenya pulling out of anything. Any more thoughts?
No, I don't have any thoughts, although I think I'm going to discuss this with Aisha on Monday to see what she's hearing from the Kenya side, to see what she's trying to get at.
Thank you. Thank you all. I'm sorry we ran out of time. Tom sends his apologies. He couldn't get on the platform. I apologize again for getting on late, but I think that was a really great session. Thank you to all of you very much, and to the audience for sending lots of questions and comments and WhatsApp messages whilst we were on the session. Wairimu, over to you, I think.
Thank you very much, Kamal. Mine is to thank the panel very much. This has been an amazing session to end the conference. Asante sana Kamal Shah, Louisa Setina, Jane Davis Evans, Tapadzwa Pasipanodia, and Tom Schneider. Thank you for all your contributions. I would like to give my closing remarks so that we can then move on to the next part of the East Africa International Arbitration Conference, which is, first of all, to invite everyone to join the Zoom link that we have posted on the chat at 6 p.m. We shall be having the Africa Arbitration Awards winners announced. This is going to be general exhibition for everyone. So please invite your friends, your colleagues to join us. This will also be aired live on YouTube, live on Zoom, and also live on this platform. And I hope you have all enjoyed the networking and all the sessions, and I'm sure you'll agree that everybody has been immensely knowledgeable. I'd like to now thank all our partners who made this happen. To be honest, we could not have done it without everyone. I will start off with the partners that we had for the Career Day on Wednesday, the 26th of August. We had ICSID, we had the Nairobi Center for International Arbitration, We had Africa Arbitration Academy and the Association of Young Arbitrators. We had Chartered Institute of Arbitrators, CIAB, YMG in Kenya, in Nigeria, and in the UK. We also had careers in arbitration. We had Secretariat. We had DLA Piper. We had Secretariat. We had DLA Piper. And SOAS, Emilia Onyema represented SOAS. So thank you all very much. I'd also like to thank our sponsors, Stevenson Harwood, Kamal, thank you very much. White and Case, DLA Piper Africa, Anjawala and Kana, 3 Veralam Buildings, Bowman's Law Firm, Kenya and South Africa, Alston Law Firm in Sudan, King and Spalding, Altamimi and Company, Polly Hogue, Howard Kennedy, thank you very much. I'd also like to thank my other members in the organizing committee, Agnes Gitau, Elodie Dulak, Leyu Tameru, our back-end team, our event management team, Steve Owor, Winnie Moretti, Harrison, thank you all very much. I'd also like to say a special thank you to every single participant who believed in our vision, who believed in what we were doing. We said we were going to have an online conference that was going to be interactive, that was going to have video one-on-one chats, that was going to have exhibition booths. You believed in us, you joined us. I was able to network with people from over, 20 countries. Some I had not met before, some are old friends. It felt like I was in a physical conference. I know I have to say that because I'm one of the organizers, but I have had that from other people. Technology comes with its adjustments. We also had to adjust during this conference, but we thank you for joining us in our adjustments. There was the good, there was the not so good, but we were able to make it. Asanteni sana. Now Can
I just say one thing on behalf of all the sponsors, all the speakers, and all the participants? This is the 8th year running, and every year, for those of us who've attended the last few years, some of us from the beginning, it has got better every year. And this year, honestly, you have exceeded yourself. I can certainly say from all the webinars and seminars I've attended in 5.5 or 6 months, this is truly the one which is the most interactive, the jokes going on the side, the WhatsApp chats, all the usual issues we have with speakers drinking on the beach and not turning up, and all of those things. It has made it a very live event. So thank you very much. And from all of us, keep doing what you do, because there's very few who match what you do with the same energy, enthusiasm, and dynamism that you bring to these events. So thank you very much from all of us.
Thank you, thank you. And let me also say a huge thank you to our other key partners who took part that I would like to mention. We had the Zanzibar Law Society, who would have been very happy to host us in Zanzibar, and I hope you will host us in future. Mr. Slim Abdallah. We had the East Africa Law Society. Hannington Amol made the time even though he was traveling. Thank you so much, Hannington. We had the AFCFTA. Wamkele Mene gave us his apologies, and Silva Ojakol represented him. We had the Africa Legal Support Facility, Stephen Karangizi. Thank you very much for working through all the technology to make sure that you were on the session. We had the government of Sudan, the Prosecutor General. We really appreciated your presence. So thank you all, and I will be stopping this broadcast in 2 minutes. And please join us on the Zoom link. You can still have access to this, to log on to the Zoom link, but join us on Zoom. It's going to be a general celebration of the awards. Thank you all, and see you on the other side.
Thanks. Bye, see you soon. Bye-bye, everyone.
Bye.